What the FBI is eliciting behind this subset is a government harassment program. Now, if you guys didn't know, there's 3 categories to the terrorist watch list: the no-fly list, the selectee list, and the KST file, which not many people are aware about, and it's where this program is taking place. The KST file, for those that don't know, is a part of a vast system of domestic surveillance for individuals whom law enforcement labels a suspect. Into this file, there's 3 sections: full investigations, preliminary inquiries, and the non-investigative subset. 97% of all the FBI's nominations is being enlisted onto the 3rd category, and it's a list that federal, state, and local law enforcement refer to as a silent hit list. Essentially is a private category that the FBI operates for the war on terrorism and contains the names of citizens who are being subjected to surveillance practices that's being done outside of the scope and regulation of the Department of Justice. And since the creation of this subset that the FBI privately established for the war on terrorism, outside of the approvals of the executive branch and the Department of Justice, there's never been an official investigation assessing the FBI's uses of this category or the practices that have been conducted within it. So this is a category that the FBI privately manages for the war on terrorism, meaning that they not only determine the policies, but also the nominations and the timeline in which citizens get removed. And just to give you a little bit of a graphical explanation on what I mean by this category being privately established by the FBI for the war on terrorism without any approvals. So the president in 2003 issued the Homeland Security Presidential 6 Executive Order, calling for the creation of investigative categories for known and suspected terrorists. The FBI, outside of those orders, created their own private category, the non-investigative subset, without any approvals or any authorizations from the executive branch. And since the creation of this subset, there's never been an official investigation assessing the FBI's uses of this category or the practices that have been conducted within it. Now, the dangers about this is that the FBI was given a lot of powers for the war on terrorism, that including collaborating with different agencies and conducting assessments on citizens. Now, if you guys don't know what assessments are, it essentially is a non-investigative technique where the FBI, along with their informants, is allowed to follow suspected citizens around day in and day out for an unlimited amount of time. And these are operations that can be conducted without any evidence of wrongdoing, a tie to terrorism, or a criminal past. And these surveillance activities are so intrusive that even since then, former Congress members Nancy Mace and Jamie Raskin called for the Government Accountability Office to investigate this operation within the FBI. But despite their attempts of getting the GAO to do this investigation in 2015, it was never done by the department.
So, just by way of background, the Attorney General's guidelines were originally implemented to prevent the recurrence of the 1960s era widespread FBI intelligence collection on Americans. And they aim to do that by limiting the FBI's intelligence collection role and trying to ensure that FBI activities were tied closely to impending wrongdoing or violence or threats of some kind. Over time, the guidelines have evolved and gone through a series of revisions. And throughout these revisions, including the latest one in December of 2008, implemented by then Attorney General Michael Mukasey, there have been 4 consistent trends in the changes to the guidelines. The first is that the necessary connection between an investigation and criminal activity has become more and more attenuated, so that tie between FBI activities and impending crime has gotten further and further apart. The FBI also needs less evidence to initiate investigations and to advance investigations to the next stage. Third, the more intrusive investigative techniques are being permitted at earlier and earlier stages of investigations. And oversight mechanisms such as durational limits on investigations or requirements for getting supervisors' approval for various tactics have been rolled back or eliminated entirely. So that's been a trend really since the Reagan administration, essentially. But in addition to these trends, the Mukasey guidelines also implement a new investigative phase called an assessment. And an assessment can be initiated when there's absolutely no individualized suspicion or indication of wrongdoing whatsoever. But even while there's no proof of wrongdoing needed to initiate an assessment, at the same time they permit highly intrusive investigative techniques. So the government can send informants into political meetings or religious services. They can pretend to be a new neighbor or business associate in order to ask your friends and colleagues about you. And they can engage in physical surveillance of unlimited durations. They could follow someone day and night. And this is with no evidence of wrongdoing or threat. So the driving force, I think, it's pretty much agreed for both the changes in the Mukasey guidelines and the trends that I mentioned before, is the increased focus on intelligence collection as a means of preventing crime, and particularly terrorism.
No one's saying that the FBI shouldn't be allowed to investigate cases where there is some basis for reasonable suspicion of criminal activity. Lawyers in the room will be familiar with that. The long-established Fourth Amendment standard for searches and seizures. The concern here is precisely that the FBI requires neither evidence nor even suspicion to employ its most intrusive investigative tactics. And let's not lose sight of the history here. The reason there is a set of FBI guidelines at all is that 40 years ago, the Bureau was engaged in a wholesale, what the Church Committee, Committee of the Senate, called a sophisticated vigilante operation aimed squarely at suppressing the legitimate exercise of First Amendment rights. And we are not as far removed from that history as we might care to think, especially when looking at the latest form of the guidelines, the Mukasey guidelines from 2008, essentially invite COINTELPRO again.
So I would just like to add that before the assessments existed, the FBI would refer to the limited checking of leads, which was something that they could do before, when they didn't have enough evidence to open a predicated investigation. So it's not as if before assessments were created, agents were powerless to follow up on tips like that. What they were is more limited in the tactics that they could use. So
this activity, mind you, was never amended for the purposes of it being carried out within the FBI's private subset. But when you're amending something like this and you're not conducting supervision over this category, where do you think a majority of these activities on the KST file are going to take place, right? So that's essentially the alarms going on now with handling codes 3 and 4, right? We're essentially witnessing the same factors that led to COINTELPRO now happening within the FBI's private category.
Many of them knowingly are placing innocent civilians and they're treating them as domestic terrorists, even though they know that they don't meet the standard. Want eliminated those categories 3 and 4 because they are unconstitutional and because this list that is shared with 18,000 law enforcement agencies, state, tribal, and federal, over 530 something corporations, the biggest corporations, and 1,440 entities, nonprofits, and NGOs. You know, the Supreme Court has said in a case called TransUnion versus Ramirez that you cannot spread information, calling somebody a terrorist, spread it to third parties, because that is, defamation, and that causes damages. So we filed a lawsuit to eliminate this list.